What is a will? A will is a legal document which expresses your wishes as to what you wish to happen with your money and property when you die. What are the requirements to make a will valid in law? It must be written down. It must be witnessed by two persons present at the same time who cannot be beneficiaries. It must set out the wishes of the person after his death or her death. Now, who can make a will? Anyone aged 18 years or over can make a will. What are executors and trustees? These are the people set out in the will to carry out the deceased person's wishes. Normally, trustees are appointed where there are children, and these children are beneficiaries. What is a guardian? A guardian is a person appointed under a will to take care of a person's children who are under the age of 18 years. A guardian need not be a trustee or executor. Guardians normally look after the children of the deceased person, but the executors and trustees look after the money and the business side. What if I do not make a will? In this situation, the state or the government regulates your affairs. If you have a spouse, then 2/3 of all you have goes to your spouse and 1/3 goes to the children. If you have no children, everything goes to your spouse. If there are children and no spouse, then everything goes to the parents. If there are no parents, then everything goes equally to your brothers and sisters. And if there are no brothers and sisters, then the beneficiaries are uncles and aunts, and so on, to more and more remote relatives, who may be people you don't even know or you don't even like. You will see, therefore, how important it is to make a will. At least it means you have a huge element of control in where your money and property goes. Not making a will means that whatever you have may end up with people you neither know or like. If there is nobody and no family, the last and ultimate beneficiary is the government. So you don't want the government to get your money. Can wills be set aside? The answer to this is yes, in certain circumstances. For instance, if the legal formalities are not correct, you may have no witnesses, or you may have only one witness, or the witnesses may sign incorrectly. Then there's what's called undue influence. For example, a son or daughter puts moral pressure on an old parent to leave everything to them. Well, in that circumstance, the will could possibly be set aside. There is lack of capacity. For example, a person is too young or of unsound mind, or the person could have Alzheimer's or dementia. Now, this is very relevant today because a lot of people are living a lot longer, and because of this, they're coming down with Alzheimer's or dementia, or they could even get a stroke. And if you get a stroke, you're also incapacitated and you can't make a will. Now, can you make a will and completely disinherit your spouse? Some people want to do this, but the answer is no, you can't. There is what is called the Succession Act, and this makes sure that spouses and children are protected in certain circumstances. For example, if you have a wife and no children, and you decide to leave all of your money, for example, to the cat's home, then notwithstanding your will, your wife will still get half of what you own. If there are children, then your wife can still get 1/3 of your property, and the children can make claims against the other 1/3. For example, where they are at school or in full-time education, but they must have a claim made. You can see, therefore, that making a will, you have freedom to say who gets your money and property, but this right is limited by the state in the public interest, and it ensures that people go some way towards honouring their moral responsibilities. Wills are most important and give you an opportunity to look after your family in a fair and just manner in accordance with their needs. This is especially important where you run or own a business. Now, can I prepare a will myself? Yes, you can, but it's not a good idea since most people don't know the law adequately, and if they make a mistake, the will can be set aside. It is best to get a lawyer, in this country normally called a solicitor, to do the will for you, and a simple will cost in the region of €250 or thereabouts. When I die, what happens with my will? There is no registration system in Ireland for wills, so usually before you die, you will have told your executors and trustees that you have appointed to look after your affairs where your will is stored. Most people store their wills with their solicitor or at home or with a bank. When the will is located, the executors then have the job of carrying out your wishes as set out in your will. This is a complicated process and normally involves the help, again, of a solicitor, especially when a house is involved and a business needs to be sold. The will itself is not sufficient to collect money from your bank. You just can't go along and say, here's my will, give me the money. To collect the money, or indeed insurance, you need to take out what is called a grant of probate. A will is not good enough to sell your house either, so the grant of probate is the next step. This involves setting out details of your deceased person's assets and liabilities, and these details are given to the probate office of the High Court, not only to obtain the grant of probate, but to determine all tax liabilities. Obtaining this document at present can take up to 9 months, and it's particularly difficult with COVID. The grant of probate is a very important document, and when it issues, it enables the executors to collect the deceased person's money. It enables them also to gather any other assets there may be, for instance shares or money abroad in certain circumstances, and to pay the deaths and funeral expenses of the deceased person. The balance of the estate after all the debts are paid is then divided out by the executors in accordance with the deceased's wishes. So there you have a very brief summary of the law on wills in the Republic of Ireland and how it all works. To be sure, it is best to engage a solicitor or a lawyer and an accountant if necessary to deal with the tax side. If you are an executor, my advice to you is do not try this yourself. It's very, very difficult. Now, what if I don't make a will? In this instance, the law of intestacy applies, and the state has laid down how your property and money is to be divided. I briefly mentioned this before, but if you leave a spouse only, he or she is going to get everything. If you are a spouse and there are children, 2/3 of the estate goes to the spouse and 1/3 equally between the children. If there are no spouse or children, then the parents come next, then brothers and sisters, after that uncles and aunts, and so down the line with the ultimate beneficiary, the state. There is a different tax treatment for all beneficiaries, and various tax bands apply. What is known as a grant of administration must be obtained through the courts, just like the grant of probate I described to you previously. And various people are entitled to apply for this document depending on how close they are in relationship to the deceased person. The spouse is normally the first person in line, and then a child or children. When the grant of administration issues, the administrator, as the person is called, like an executor, collects all of the assets, sells any property, pays off the debts, and then divides what is left over among those entitled in law, as distinct from a will, those entitled to law, in law. Normally, most of the money goes to the closest relative surviving the deceased person. You will see, therefore, that the situation is very different from when you make a will, and people you never intended to benefit may become rich at your expense. So that's something you definitely don't need or want. My final advice in all of this is get your solicitor to do the work. Go and find a solicitor if you haven't one already, and don't leave it all to chance.